And these are some of the topics that we are going to be covering today. Basically, be giving a overview of rent control, answering what is the lawful rent under rent control, unlawful rent increases, amenities, maintenance, and rent decreases, and the eviction protections that are available under rent control. And then, so we're just going to be giving an overview of what rent control is. So the rent control law became effective on April 10th, 1979. It was passed by voters in 1978. And it established a governing body separate from the city council and a source of funding separate from the general fund. So right there you can see the current 5 members of the board. And you see the structure right there as well. The 3 departments answer to the administrator, and then the administrator answers to the rent control board.
Right. So part of rent control is that, just like today, it was a growing shortage of housing. And so the voters got together, and that's how rent control is enacted. It's just because the same situation is going on today because of rising rents and a growing shortage, and owners were demoing their apartments without the proper procedure. So that's why we have this governing body now.
Okay. And so most of the units subject to rent control, most residential rental units in buildings constructed prior to April 10th, 1979 are subject to rent control. There are some exceptions. Most single-family homes would not qualify, most condominiums, most owner-occupied properties with 3 or fewer units. And then there is, a lot of the time we get a phone call to see, or someone comes to the front counter to see, am I under rent control? A way to generally look at this, we do have a tool on our website. It's the Look Up a Rent feature. It's probably one of the most popular features on our website for tenants to see if they are under rent control.
Okay. So in essence, the rent control law, all rent increases during a tenancy are controlled, and remedies are provided for situations where excess rent is charged or maintenance is neglected. And one of the most powerful features of rent control is the eviction protections, where the owner just cannot ask you to leave. They have to have a just cause under the rent control law to evict a tenant. And then another protection is that an owner just can't remove the property from rent control. They either have to have some kind of removal that's granted by the board, or else there is the Ellis Act, which we'll get into later.
Mm-hmm. Okay. So today our focus won't be on the following issues. And you'll see right here on the left, the state law issues, return of security deposit, the right of a landlord to enter a tenant's unit, eviction procedures, noticing, and then there's, if you see here, there's a QR code that you can use with your cell phone to scan that, and that will take you to the California Tenants Guide to Residential Tenants and Landlords' Rights and Responsibilities. So that's a very helpful guide for a lot of tenants to see what their rights are under state law. Like you see right there, those issues above. It'll give you more basically in detail, for the most part, of what the rights are in regards to these subjects. We also won't be focusing on municipal code issues. So this includes tenant harassment, permanent and temporary relocation amounts, building code violations, short-term rentals, and smoke-free residential ordinance. So we won't be really delving too much into these, as they are part of Santa Monica city law and not particularly the rent control law.
Right, and then a really helpful handbook by the state is the California Tenants Handbook, and I can show you that here. It's a really thick book, but it's very helpful for all tenants in the state of California. And it goes through state law issues like security deposits, getting your security deposit back, things like that. So it's a very helpful handbook to download.
Okay. All right. And I will begin with this one. So I'll be starting first with what is lawful rent? So it's how do we determine the lawful rent for a rental units? We're going to be talking about how rents can change over time. And we'll be going into what is unlawful. So there's two distinctions that are very important to know. One is maximum allowable rent, the MAR. You'll hear that term often, versus the maximum lawful rent. So the MAR is basically, we set that, that's something that's set with the general adjustments, what the maximum that they can charge you before any registration fee pass-throughs or allowable surcharges. That would make in total the maximum lawful rent. So those are two distinct terms. So sometimes tenants will be saying, well, I'm paying more than the MAR. And that usually a lot of the times is because you're paying the registration fee pass-throughs that are allowed and the allowable surcharges. And we'll go a little bit more into that next. Okay. Right here you'll see how the MAR is determined. So there's two separate distinctions. There's January 1st, 1999 tenancies and post-January 1st, 1999 tenancies. That's a big distinction. So for pre-January 1st, 1999, the MAR is based on the rent in effect on April 10th of 1978, plus all subsequent increases approved by the Rent Control Board or otherwise allowed by the rent control law. So if you are a pre-99 tenant, when you moved in, all the increases, the subsequent general adjustments that have occurred over the years is what your MAR would be up to. Now, for post-January 1st, 1999 tenancies, if your tenancy began this period or after, the MAR is based on the initial rent charged at the beginning of the tenancy, plus all subsequent increases approved by the Rent Control Board or otherwise allowed by the rent control law. So that's going to be based on when you moved in. For the most part, the landlord can charge a market rate when there is a new tenant who is moving into the property. And then your MAR would be based on all the general adjustments since you moved in that they were allowed to take. Okay. So the Rent Control Agency keeps track of all of MARs for all controlled units. And that's, I was talking about the look up a rent tool on your left. Right there you can see circled in red is to look up a rent. So you can type in your address. And generally when results come up, for the most part, that would mean that it's under some sort of rent control. You can always, if you have some doubts or you see a number there that looks suspicious or strange, you can always give us a call or contact us so we can go ahead and explain. Sometimes it does occur where the owner does not register for one reason or another the tenancy, which is the MAR. So that's really helpful. You can contact us and then we can communicate with the landlord that they do have to do this. And then you may have received the newsletter recently that we sent out. In that newsletter in the back, you most likely saw that blue circle on the top right of the screen. So that's basically what the current MAR, according to our records, is for your unit. Again, that may sometimes it's not accurate because we have not received an ownership registration, or perhaps there was some sort of error when the tenancy registration was submitted to us by the owner. So if something looks off or anything like that, please contact us so we can go ahead and further investigate on that. Okay. So the registration fee. An annual registration fee for controlled units is charged to property owners by the Rent Control Board. So that's to all rent control units. So the current fee is $228 per unit per year. And as long as an owner pays the annual fee on time, it's usually by August 1st, 50% of the registration fee may be passed through to each tenant by including an additional $9.50 per month in the tenant's rents. So right here you see the MAR plus the registration fee pass through plus allowable surcharges would be the maximum lawful rent. And again, they have to pay on time. We'll be sending those out in late June, the bills to the landlords, and they would have to pay by August 1st in order to be able to pass that on to the tenant, that $9.50. Okay, now we'll talk more about the allowable surcharges. So it's very important to note, this only applies to tenancies that started before March 1st of 2018. So if you did not, your tenancy started this date or after, the landlord would not be able to pass these surcharges onto you. So allowable surcharges are based on an owner's property tax bill. These costs can be divided among units on a property and passed through to the tenants. So when you would receive a notification of a rent increase, they would have to include that property tax bill there, so they can, and then there would be a calculation of how they arrived to that, and we'll look at that in a little bit. Surcharges for existing tenancies are capped at 4% of the MAR or $35, whichever is less. So $35 is the maximum they'll be able to charge you. However, they still have to show you their work on what number they arrived. It doesn't mean that they can automatically do $35. They have to actually do the formulas, and they'll show you right there on the registration tenancy, the change in the terms of tenancy. And so, like I said, surcharges cannot be passed through for new tenancies beginning March 1st, 2018, or if a building was sold or has its value reassessed after that date. So even if you moved in before March 1st of 2018 and it's reassessed, and generally that happens with a sale, then that means they still cannot pass that along to you anymore. They may have been able to before when it had not sold, but now that it has sold for value and has been reassessed, they can no longer pass that along to you.
Are you open to questions at this point?
We're going to have at the end of this section, we'll have for questions, open for questions, yes. Okay, and then so this shows property tax bill. This is a sample of it. It lists the terms used for the specific costs as they appear on a property tax bill. So you'll see the ones that they're able to pass on would be 5A through 5E right there on that figure. So the owners, like I said, must provide a copy of the tax bill to tenants with their rent increase notice to pass through most surcharges. So they can't just, they just can't say, well, this is what it is, and this is what you have to pay. They actually have to give you a copy of their property tax bill, and that has to be included if they're passing those surcharges on to you. And then you can see the 5 items there: the community college bond, unified schools bond, school district parcel tax, Santa Monica stormwater management use fee, and the clean beaches and ocean parcel tax. Okay, now the general adjustment. So the purpose of the general adjustment is to provide property owners a fair return. So it is based on 75% of the percentage change in the consumer price index, known as a CPI as well, for the Los Angeles area for the 12 months ending in March. The GA for this year, it's not been finalized yet. However, it won't be more than 3% per rent control law. It cannot be more than 3%. And a lot of the times there is also a dollar cap, which has been the case in previous years. And it will be decided in June if and how much the dollar cap will be by the board. And if the unit qualifies and with proper written notice, the general adjustment can be implemented as early as September 1st of each year. So that's the earliest that they would be able to do it. They can still, even if they missed that time, they can still do it as long as they paid, they gave proper notice and they've been making payments for their registration fees. As long as they do that, they can take the increase generally on September 1st. But they can, if for some reason, sometimes they miss it or something like that, they can still apply it like for the next month, October 1st, they can do that, or November 1st. So they don't lose the ability, as long as they have paid their registration fees and have given proper notice, they can still take the increase at a later time if for some reason they did not on September 1st. And so, like it said, it does not expire and can be prospectively implemented with proper notice. And this is the notice of rent increase. A lot of you may be familiar with it, right there on the right side. Basically, this is the one that would include the surcharges. So if a tenancy that began before March 1st of 2018 and the building has not been sold or reassessed for value, you can see right there, they would have to put your name, what the old MAR was right there, what the general adjustment is that they're going to be basing it off of, and what the new MAR would be. If they are not required to, most landlords do pass that $9.50 if they are able to. So most likely you'll see that $9.50 there. And then this is where they would explain what amount you have to pay right there. So what amount was billed to them, and then the number of units on the property, and then the annual fee per unit, and that would be divided by 12. So that would get the monthly per unit that you would be charged per item. And then that is where you get the property tax bill to verify, to cross-reference for yourself any of the numbers that they gave to you. However, if you moved in March 1st of 2018 or afterwards, or if you did not, or if the building has been sold or reassessed for value, you would not see this surcharge table on there. It would be more simplified. It would not contain that C section with the chart right there. So now in section D down there is where the new maximum lawful rent would be determined. So we would add the lines 3, 4, and 5 to make that maximum lawful rent. Like I was saying before, so if the number on the table exceeds, the calculation exceeds those $35, they have to do $35. They can't, let's say it comes out to $40, $50, the calculation. They would have to do the $35 for that. So they would have to show their work there for everything. And then, of course, the signature right there and the date. And they would have to give you that notice, give you a 30-day notice if for some reason if there is a general adjustments that have not been given in previous years, and then the landlord decides to bring it up to the MAR, and that is over 10%, that would be a 90-day notification, but a 30-day general notification for any increase under 10%. Okay. And for the surcharges, there are some waivers. So we're going to talk about the registration fee waivers. There is the low-income senior tenant fee waiver, that $950, and the low-income disabled tenant fee waiver. So if there's approval, no registration fees are charged for the unit the tenant occupies, and no registration fee surcharge may be passed through to the tenant of the unit. So that would work. The tenant would submit that to us. There are applications, go through the process, and then if and when the tenant is approved, the landlord can no longer pass that along to the tenant. And then there is the Clean Beaches and Ocean Parcel Tax Surcharge Waiver. So this is for low-income tenants that may apply for a waiver for their units. And if a waiver is issued, this parcel tax is not charged for that unit, and the surcharge may not be included in the tenant's rent again, and that would be part of the property tax. And this is assuming that you're eligible for a property tax surcharge pass-through. So this all dependent on if you are being charged that. Okay, and I'll open up for this section. Any questions on this? Yes, ma'am? I'll bring, oh, yeah, you.
I'll go ahead.
I'll just bring the mic right now. Thank you.
The statement about surcharges not being passed through if a building has sold since your tenancy began. Our building has just been sold, and our new rent statement from the new landlord includes all the surcharges and stuff. What, if anything, do we do about that?
Well, you can definitely talk to the landlord and let them know that per rent control law, that is not allowed. And a lot of the times, for one reason or another, the management company won't know, even though we try our best to notify all management companies and all owners of the information. And then, so basically, if they still are charging you those surcharges, we do our remedies for that. If after you tell them, and you can even tell them to call us, to contact us, to verify. It's on our website as well. If they still insist on doing that, then if our remedy would be, and Karen will be talking about that a little later, would be the excess rent petition. Basically, if you're paying those charges and you shouldn't be, there may be an opportunity for you to get that money back. But usually the best course of action is to speak with the landlord and make them aware of the law. Usually, once they're made aware of that, they'll revise. They usually issue revisions, but we do have some remedies under rent control for that. But they're not supposed to pass those along to you. They're not supposed to do an increase passing those along to you.
Okay. And for all of our purposes, what is considered to be a low-income senior in Santa Monica?
Low income, I believe it's 20. Let's see here. I would have to get the exact figure. Let me take a look here. Would have to get that exact figure, but I believe it's right now it's around 30-something thousand. I'll have to get the exact figure for you for that, but I will go ahead and get that to you just as soon right now. Get the exact one. Thank you. Yes, sir.
To not incur the wrath of a new landlord or to get off on the wrong foot, can we contact you instead and have you contact that new owner to inform him that he should not have passed on those charges to all of his tenants?
Well, if it's something, you can contact us and then we can review the issue, especially if it's being done on a building-wide basis. If it's affecting many tenants, you can definitely contact us and then we can go ahead and review the issue and see what we can assess, what we can do about that. Any more questions based on these?
Yeah, and it doesn't matter what kind of year that the building closes escrow and it's a new owner, right? I mean, like the succeeding months, let's say it closed mid-May, so it's portion of May, June, July, and then the new rent would not include it. And August, when they actually send out the new rents, it should not include that.
Correct, yes. They should not, yeah.
Okay.
I'm just amplifying on what I've already heard. The building that I live in was sold about 2 years ago. The management company is assessing those charges. So is this forever that they can't charge it, or how does that work?
Yeah, they can't charge it, yeah, if they recently purchased it, yeah, they can't.
Even if it's a couple of years ago?
Right, yeah, if it was 2-3 years ago, they're not able to, and if you have been paying that all these years, then the excess rent remedy, which we will talk about in a little bit, may be available. That's what we have under the rent control law. If they do not, if you bring it to their attention and they choose not to refund it to you, the amount that has been overpaid,
Thank you.
of course. Any other questions? Sir? Oh, yes, we'll be getting to that shortly. Okay. Okay, so you want to do unlawful rent increases?
Okay, our next section is unlawful rent increases. So besides the maximum allowable rent and the board controlling the annual increases, there are unlawful rent increases. So, charges for additional amenities. It is allowed in certain circumstances. So it has to be by mutual agreement. It can't be something that's arbitrary where the owner says, this is $200 for parking, take it or leave it, and you don't agree to it. It has to be by mutual agreement only. And there are specific requirements depending if you're a pre-1999 tenant or a post-99 tenant, and we'll go through that later. And again, charging for additional amenities without a proper agreement may constitute collection of excess rent. So for pre-1999 tenancies, the owner and tenant can negotiate a separate agreement. It's separate from the rent, and it's at an arm's length transaction where each party agrees to it. So these amenities are like perks, like you can have parking, or there could be amenities to have a pet, a separate agreement for a pet. I had a tenant, and his rental agreement said that he couldn't have a pet, but he wanted this pet, and so he was a pre-99 tenant, and he and the owner agreed to a pet amenity, so that it was separate from the rent, but it's something they agreed upon, and they had it in writing. So, and then it must contain certain comparable to those of similar arrangements in the unregulated market, like parking. If you can look around, you can see what it's charged for parking, because sometimes there's parking. You can see that some owners are charging $200 commercially for parking. So you can kind of get an idea of what parking is in a comparable similar area that you're in. Also, parking differs if parking is difficult in the area, and you may want this parking. So you may want to go into a separate agreement if parking becomes available. And then also, this additional amenity is not contingent upon your tenancy. So it's something that you mutually agree upon. And also, breach or termination, both of you can agree to terminate it. So it's not grounds for eviction. So for post-99 tenancies, it's totally different. Because when Costa-Hawkins came into effect, and for post-99 tenants, everything starts over. So when new tenants move in, the owner can reset the rent, he can reset amenities. But also, post-99 tenants, they can register if, for example, maybe when a tenant moved in, there was no parking available. If parking becomes available, they can add that by a mutual agreement of how much, the owner and tenant agree on of how much the parking is going to be. They can add that, like parking, garage, storage, or right to have a pet. So again, the requirements, it's an arm's length transaction, no pressure. And again, the amount paid has to be comparable to lawful arrangements in the unregulated market. And the board, you have to register, the owner has to register the additional amenity on a board-approved form. So there is a form that the owner has to use to register that amenity so that we know what is added to the MAR. So with additional occupants, there is no separate agreements for additional occupants, for post-99 tenancies, and for pre-99 tenancies. So, and a person's or a tenant's right to sublet, that has to go to the rental agreement. If your rental agreement has provision in there that allows you to sublet, or you have to have permission, then that's something you have to abide by, or else there could be grounds for eviction. And also under the municipal code, the city ordinance, that it prohibits an eviction of occupants based on addition if it's due to marriage. So your partner, your marriage partner, they're allowed to move into the unit irregardless of the rental agreement, what the rental agreement says. Domestic partner, they're allowed to live in the unit. Or your children, if you have children, they're allowed to live in the unit, and adoption or change of legal custody. That's all in the city ordinance. So another feature of Costa-Hawkins is that, and tenants have to be aware of this, if a tenant sublets and they no longer permanently resides in the unit, the owner may be entitled to go to market. So tenants really have to be aware of this, that subletting your unit and you live somewhere else, that may entitle the owner to go up on the rent. And then we come to utility cost. And we know, cost of utility is always going up, but it's usually where, if a unit is separately metered, mostly tenants have it in their name and they're paying, the utility costs like electricity or gas. But if the property is master metered, the owner has to, at the onset, put that into the tenant's rent, and it can't fluctuate. So, and this is for post-99 tenancies. When the tenants begin their tenancy, the owner has to put what they believe the cost of the water is going to be and put it at the onset of the start of the tenancy. And usually for pre-99 tenancies, there is no additional charges for utilities, because it goes back, that's partly an amenity, and it goes back to the original registration form that the owners filed with the Rent Control Board back in 1979, where they listed what the amenities are for units, and it usually included water. And then we have the tenants not in occupancy. This is a petition process where an owner, if he believes a tenant is not occupying their unit, they live somewhere else, the Santa Monica residence is not their usual return, then they can petition the board to increase the rent. It's not an eviction, it's just the board they petition the board to determine whether that tenant actually lives in that rent-controlled apartment. And so a decision in favor of the owner is not a reason for eviction, it's just going up on the rent. And here we come for the complaints for excess rent. This is what we have for tenants if they're being overcharged. So I usually do the excess rent complaints with the board, and you first have to give notice to the owner, telling him you owe me this amount of money, and maybe reasons that they owe you this money, and then you keep a copy, you wait 30 days, and then you file the excess rent complaint. And the board, it goes through a whole process where we'll try to mediate between you and the owner of the management company, and if that's not successful, then it goes to a hearing. And a hearing officer determines whether or not there's excess rent, and then she can determine that withholding of rent is warranted. So that's how we kind of adjudicate any kind of excess rent, is just through our excess rent process, and it's been very successful for tenants.
We'll open it up to questions.
Questions?
Questions? Oh. Is this one first?
Yeah, I have a question about utilities. The building where I live has recently been sold, and would the owner now, currently we don't pay for water, but could the owner now charge us for water?
No, they can't charge you for water, since the new owner cannot charge for water because it's an amenity, because they haven't been charging it. So it is also master metered, and it's something that you can't really tell which tenant is using what. So that's why it's since for pre-99 tenancies, water, no, it can't be added to a tenant's rent.
Because the ownership changed.
Right, it still stays the same whether ownership changes, so your rights are still in place.
Okay, thanks. Here, Lori.
If they try to do it,
That's what we're here for. If they try to do it, just call us.
So, if an owner 30 years ago failed to register amenities but has been providing them for 30 years, and a new owner takes over and says, "Oh no, you're going to pay for those amenities now," what kind of protection do you have on that?
Well, we're talking about pre-99 tenancies.
Yes.
We have to look at the original registration form to see what the owner listed. And it's usually a very basic form that said, these units get parking, they get storage, they get utilities, water. We have to look at that. And if they didn't list anything, then that's something that we can't really, a tenant can't really file something like a decrease or excess rent, because that's an amenity that the owner didn't list. And they have to, that's what we rely on, is that original registration form that lists the amenities for pre-1999 tenants.
Okay, so if there's obvious amenities like 4 parking places directly under the place of residence, and if the owner, I don't know whether our owner registered those amenities or not, but if they're obvious amenities, is there any defense for that?
Well, if we have, like, your example is parking, and your pre-1999 tenant, again, we have to look at the original registration form. There's no way out of it, but we have to look at the original registration form to see what the owner listed. But if somebody lived there April 10, 1979, they can offer testimony that says, I lived there April 10, 1979, and I know what was there. Mm-hmm. So that could be something that could be utilized in filing in a petition.
your lease says that you were entitled to those few parking spots or whatever.
For pre-99 tenants, we don't go by the lease. For pre-99 tenants, we don't go by the lease. We go by the original registration form and what the owner back then registered.
Pool furniture, they can't withdraw the pool and they can't withdraw the furniture.
If there was a pool, normally we have that on the registration form, so owners usually checked off those types of amenities, pool, recreation room, something like that. But it's something that if it was there, then yes, that's an amenity, the pool. And like I said, if tenants usually can testify if they were there April 10, 1979, that they were there and that amenity was there, then we can take that testimony.
We could drain the pool tomorrow, there's nothing you can do about it.
If they drain the pool, then that's a decrease petition, because you're taking something away from you that you enjoyed.
Speaking a little more about that.
No, they can't leave, that's maintenance, so it's like, yeah, you gotta fix it.
Is it possible for us to go in and check the original registration?
Yes, yes,
So,
yes, you can come into the office, we'll pull the original registration form to see what the amenities are for pre-1999 tenants.
Hi, my question is regarding an increase of the rent. When the tenant is not physically in the unit, is not living there or out of the country, what is the frame time for the increasing of the rent? Could be couple months, could be days, weeks. What could be the frame that the owner could say, oh, the tenant is not living there?
Well, again, the owner has to file something with us, and he has to send the tenant a form saying, this is, I believe you're a tenant non-occupancy, this is what I'm going to be filing. Once we get that, we're going to send something to the tenant saying, well, do you live here? Yes,
For
no?
whatever reason, the tenant is not physically there, and you know?
It's just, it's what your usual place of return is. If you're going off on vacation, or there are some reasonable things that are allowed, like if you're on a sabbatical, you have to go away because of something that's work-related, like you're in the movie business and I have to go to Atlanta, Georgia for a while, then yes, those are exceptions.
Yeah, but the time frame that the tenant is allowed before, the owner could say, oh, just waiting that he or she is not there and increase the rent.
No, it's a whole process, so it's not just cut and dry.
Just,
No, they just can't do that because it's a whole hearing process.
okay. It's
Yeah.
It's more than.
Yeah,
12
it's more
months
involved.
or weeks.
They have to prove
Yeah,
They
you
have
still
to
have-
prove
you still keep
that
a
you're not
bedroom
living
there, you have
Oh,
items there,
but
you
Yeah.
it's not physically.
left for 6 months or 8 months.
Yes, let's try to raise our hands and so I could pass the mic around so everybody could hear the questions, please.
I have a question. My apartment is on a shared meter, and I'm just looking for confirmation. My understanding is that under Section 8, the utilities cannot exceed the maximum allowable rent established by the Rent Control Board for Section 8 apartments. It's supposed to be either included in the rent, or if they want to charge it, they can break it out into a dollar amount, but it still has to be, add up to the maximum allowable rent. Is that correct?
Well, we don't know. That's something that's Section 8. We refer a tenant to Section 8 because they know about the federal government and they know about the laws governing that. What the rent control law and what our law basically is the MAR. Even though the Section 8, they may base it upon our rent increases or our MAR, it's still we're separate agencies. So we can't tell you what Section 8 does, and we would have to refer you to Section 8.
Okay, thank you. I have other questions, but I'll wait
Okay,
until
sure.
the section comes up.
Yeah.
If on your original lease, post 1999, or if it even matters, has two family members, in this case, mother and daughter, and then the daughter moves away for 10, 12, 15, say 10 years, can that daughter, if she, for whatever reason, come back into the unit if she was on the original lease?
Well, if the original tenant or one of the original tenants doesn't leave, yes, she can come back. I mean, even original tenant, if there's two people on the lease, and we're talking about post-99 tenants, if there are two people on the lease, one leaves, then under the rent control law, the original tenant can replace on a one-for-one basis. So they would have to give notice to the owner, and the owner has 14 days to respond to the tenant's request. Or else, if the owner is just unreasonable, then a tenant could file for a rent decrease if he doesn't allow the additional occupant.
Okay, all right. I'm not sure I quite get that. And the other part is if a family member, can a family member replace another family member on a lease? Somewhere I heard that, and I just curious.
Well, again, it goes to what the provisions of the lease are, and also if you need permission from the landlord to replace. But if we're talking about post-99 tenants, it's again under our law, it just says it's an amenity. If you have two people, that's like a perk you have, it's two people. If one original tenant leaves, then the remaining original tenant can ask for a replacement. It could be anybody, it could be the family member. It's just you're replacing that person. So you can again have two people that are that's an amenity.
I see. Okay, thank you.
Any other questions?
Hello. I just wanted to ask you a quick question, and we got a new owner, and he decided to build ADUs on top of the garages. Okay, so we live in a fourplex now. It's 6 units. So he's finishing building on top of the garages. The garages were reinforced. And we signed the lease, we got the reduction of rent temporarily. And so what's gonna happen with the garage?
What's going to happen with the garage or the
Yeah, the garage,
ADU?
because the garages are empty.
Well, I'm sorry, she's not being totally clear. Basically, the owner doesn't seem to want to hand off the original 4 garages to the 4 original tenants of the original property prior to the new ADUs. And so he basically said, you guys have to vacate a year and a half ago after all this construction permanently. So we reached out to him again the last week or two saying, hey, would you please hand back these garages to reconsider? And he's been ignoring it. And we want to know where, what can we do? And we've been told that we need to go for a permanent reduction of rent, but we
Yeah.
would prefer, of course, to get our garage back because it was a huge garage with storage. And they took away, of course, the entire patio, communal areas in the back, building these ADUs within 5-10 feet of our bedroom windows for all the tenants. So there's literally space just gone. For, ADU apartments that look over a
Right.
garbage alley. It's madness.
But the garages is still there.
Yeah, the 4
Garage
garages
still-
are
And you
still.
had use of the garage.
And what about, does it matter if it's pre-1999? If you're pre-1999, it was a base amenity, then you'd still be able to have it, correct?
Well, again, if you lose a garage that's a base amenity, the remedy is going to be a rent decrease. And we're going to get into the rent decreases in the next slide.
Okay. Thank you so much.
And then we'll move on, and we'll have time at the end for more questions on these topics as well. One more question, or? Yes, sir.
We'll wait till the end.
Okay.
Okay. So now I will be discussing amenities, maintenance, and rent decreases. We've already talked about a little bit about that, but we'll be going into more detail right now. So, owners are required to maintain the property base amenities and housing services. Amenities and housing services that were provided on the base rent date, as well as those required by law, must continue to be maintained and provided. So, big examples of this includes parking, appliances, the right to have roommates, includes common area housing services and amenities like was mentioned, a pool, gardening, laundry, recreation room, things like that. So the owners must maintain the conditions of a unit. That is something that they are required to do. So examples of maintenance include water leakage, worn paint, flooring, broken windows or doors, screens, insect or animal infestation of the unit, heat, plumbing, smoke alarms, counters, the grout. Those are just some of the most basic examples. More things do apply. So, the tenant can petition for a rent decrease when an owner reduces or removes a base amenity or housing services, or fails to make necessary repairs. So decreases are calculated from the time the petition is filed. So basically, the rent decrease would remain in effect until repairs are made or the amenities or housing services are restored. So basically, with the rent decrease petition, the process that happens is if it was a base amenity based on whether you're pre-1999 or post-1999, when that, whether it was a base, if it was a base amenity and something, like parking that was included, laundry unit, anything like that, if that has been taken away from you, so first, it has to be taken away from you. It can't be. You can't do anything before the amenity is actually taken away from you. Once that amenity is taken away from you, you would notify the landlord either in writing an email, sending a letter. We also have a form on our website that many tenants like to use because it says Santa Monica Rent Control on there. Basically, you can check off or state what amenities that you would like back. And within 30 days, if those amenities have not been restored, then you can schedule an appointment with us to file for a rent decrease petition. So the point of the rent decrease petition is really I know a lot of tenants say, well, I don't want a rent decrease. I want my amenity back. I want that to be restored. So we here in rent control, we only have power over the rent. We don't have enforcement powers to tell some landlord this amenity must be given back. We don't have that. So our solution is this rent decrease petition, because our hope is or a lot of the times, landlords, the risk of them collecting less rent from the tenant will make them restore the amenities or make the necessary repairs in the unit. So again, once you file with us, the petition with us, so after 30 days that you've notified the landlord, that's not restored, you notify us and come to the office to fill out the rent decrease petition, and then that'll be the official date that the petition will be in the system, and then from that date forward would be when the rent decrease would be calculated for that. So rent decreases, like I said, remain in effect until the repairs are made or the amenities or housing services are restored. So after the petition is submitted, eventually there is the option for mediation between the landlord and the tenant. So either party can refuse that if they feel that they for some reason, do not want to go through mediation. So if that step is for some reason skipped, then it would go to the hearing. So that would be the step after that. And a hearing officer would be the one to make the determination if a rent decrease is warranted on that. So a lot of the times, through mediation, there is a resolution through both parties that is reached, either to fix something, to restore amenity, some sort of restoration for that. And again, the tenant is under no obligation to accept something in mediation that they find is not favorable to them or that they are not satisfied with. And if they are not, then it would go to a hearing, would be the next stage, and a hearing officer would be the one making determination if the amenity was not taken away in violation of the rent control law, and then how much of a rent decrease would be warranted. And again, it would stay in place, that decrease, until the amenity is restored or the issue is fixed, the repair. Okay. And now the construction-related rent decrease. So this may be granted when a unit is uninhabitable due to construction, when construction substantially reduces a housing service, or when construction interferes with a tenant's ability to occupy the unit as a residence. No decrease is authorized for unavoidable construction impacts caused by necessary repair or maintenance unless the construction is carried out in an unreasonable manner, or the construction takes an unreasonably long time to complete. So Regulation 4400 sets a decrease range for many possible issues for this, and the decreases are calculated on when the problems arose. So, and then mediation service is still available for this. So this is different from the regular rent decrease. This has to be related to construction going on. Sometimes when ADUs are being built, things like that on the property, that can cause noise, that can cause dust, that can cause if someone works from home, that can interfere with their ability to work from home. So this is an option that is available if that construction is being done in an unreasonable manner, and it's interfering with the tenant's ability to occupy the unit as a residence. So for these, they have to be filed with us before the construction is over. If the construction is over and a tenant attempts to file this with us, we would reject that because it actually, once the date of filing the construction has to be still present on the property. So that's something very important to note. With these, the process is different. So you do not notify your landlord of your intent to do these construction-related rent decreases. You would get in contact with us, either myself or one of my colleagues does these. And basically, you would email us what the issue you are having is, or what issues you are having at the property. And then we would go ahead and send you out a petition for that. We can send you the construction-related petition. This one is a lot more involved. This one requires a lot more detail to be given, evidence such as photos, if there's videos of how it has impacted your tenancy. But that is an option that is available to you. And it's still, after the petition is taken in, it's a little different. Whereas the regular rent decrease petition that is not construction related, that would be from when you file going forward, so prospective. Whereas this one can be retroactive and prospective, both based on the date you file. But again, the very important part is that the construction is still going on when you do file with us. So that's a very big part to that. And then if mediation is not fruitful or successful, and again, it is optional, you do not have to, if you do not wish to participate in that, then it would go to hearing, and the hearing officer would be the one to make the determination if a construction-related decrease is warranted. And then it would be an amount that the rent would be reduced by, if it is warranted, somewhat similar to the regular decrease petition. Okay. All right, and now for this one, I will take questions right now.
Let's say there is a unit that's occupied by a couple, senior citizen couple, and they do have a bathroom with a bathtub in it, and the shower is in the bathtub. And they find it increasingly difficult now that one is particularly handicapped to climb inside that bathtub. Would it be viable to ask the owner to construct a new bathroom to get rid of the bathtub and just make it easier for them to walk in for safety and other reasons? To take a shower?
So they're not required to do so. You can certainly ask. They are not required. There's no requirement under the rent control law for that. However, if it's where it's a disability, that is something that the city attorney's office, they're in charge of the ADA, Americans with Disabilities Act. So if you have that, it's very likely that you can do it, but it would be yourself and at the cost of the tenant. So the landlord wouldn't be under an obligation to do that, but the tenant may have that. The city attorney would confirm if the tenant would have the right to do that themselves to, at their own cost and with agreement of the landlord to do that.
Even if proven that one is disabled?
Right. Mm-hmm. Yeah, and that is a city law, and that's not a rent control law, but so the city attorneys is the best for the Americans with Disability Act questions. Okay, any other questions?
We'll start.
In the situation of adding these ADUs, or several of them, who determines whether your unit is inhabitable? In other words, if building and safety gives permits and they get the permit to do basically anything they want, but the noise is on the roof 4 feet from your door, the dust, the advice is close your windows and close your doors and sit there in 95 degrees. And so who determines whether that's okay or not for a tenant?
Yeah, so that would be code enforcement. They make that determination if if, it's affecting like something like the dust is affecting breathing, that you cannot physically live in that unit because of all that construction, or there's the construction they're doing is causing something to the structure, the integrity of the structure, something like that. That would be code enforcement would be the one to make that determination. We would, since we only have control over the rent, we would only be able to seek a rent decrease in these cases. But code enforcement would be the best department for that.
So if you feel like it's unbearable with the noise and the heat and whatever, they can just say, suck it up, or
Well, code enforcement, yeah, the petition can be done, but code enforcement would be the one you can contact them, and then they generally would send someone out to the property and see, make the determination, yes, this appears to be uninhabitable because of X, Y, and Z, or no, this is not, this is still habitable. So they would be making that determination. Mhm. Next question?
Hi, continuing on the question that we originally asked. I want right now at the moment we have a temporary rent decrease because of the construction. So now the permanent rent decrease, because he doesn't want to give us the garages back, or if he doesn't, do we have to go through the same procedure? And is that permanent rent decrease on top of the temporary rent decrease, or?
So the temporary rent decrease that was given to you by the landlord. You didn't go through the rent control process for that?
Yes, we did.
Oh, you did. Oh, okay.
We have two mediations and one hearing.
Oh, okay. And it was the construction related decrease. Oh, okay.
They granted us an additional rent decrease because he took a lot of stuff from us, like the back patio, the storage, and obviously the garage.
Right. Well, the decrease should be in place until that's anything like that's restored. But you said they said it was just temporary for now.
Yeah, this is temporary until we don't know when he's gonna finish. I mean, he has already moved the appliances for the new apartment. So we think he's finished with the construction, but we don't know what's going to happen next. He hasn't replied back to our emails about the garage.
In other words, we're just not sure what happens to that temporary reduction that we got, on top of the hearing settlement, where they increased the rent reduction. Does that land? And do we restart if he's not handing the garages back, which means we've lost permanently the backyard and communal areas, including the garages and the storage? Do we restart the whole process with you guys to get a permanent rent reduction that's hopefully even larger than the temporary one?
Right. If you're just receiving a temporary one and then they basically say, okay, well, the construction's over, everything like that, and then we determine that yes, the construction is over, anything like that, then generally what happens if you would have permanently lost access to like the parking, anything like that?
Yeah. The garage still is there. He has 4 empty garages.
Right.
But his idea is that if he's going to rent the new units, he wants to rent them with a garage.
It would be extremely insulting to basically hand 2 garages per, ADU tenants that are, soon to, to move in, and basically essentially ignore the original 4 tenants of the original property and not give them back their individual garages. And so that's really our issue.
Yeah, anything. So with that, if it's going to be permanently taken away, that would fit into the regular rent decrease petition after that, that you generally can file. So that's if they take it away permanently. But usually they have to petition with anything with the construction related decrease, basically saying, the construction's over and they have access to everything again. So we would investigate that, or we would let you know as well that they've basically filed to say that they're now in compliance. I mean, if they do, we would basically notify you, and then you can object and say, no, my parking's still gone. They are not in compliance still, so I should continue to receive a rent decrease.
Oh,
Mhm.
okay, thank you.
Next question.
Thank you. Our new landlord has strongly hinted that they will be doing a good deal of construction. And when, he was like, oh, we're going to be upgrading the property. And you'll see a lot of construction equipment around. And we asked, will we be able to live here? And he sort of cheerfully went, no. Is there a responsibility that landlords have to existing tenants if they know that they're making the property unlivable for them?
Yes, so if it's going to be generally something like an ADU where, they're building like in the backyard or where the garages are or used to be, anything like that, or basically the garages, they would go through the permit process to, make any type of conversion. However, if it's going to be where it's affecting your actual unit, anything like that, the structure, or they're trying to change or remodel, like a complete remodel, they have to apply for permits for that, and it would eventually come to us. And if it's, and then we would have to approve. So basically it goes through other departments, and then it reaches us at rent controlled, being a rent controlled property. And then we would make the determination, yes, this can be done. However, if it causes you, to not be able to, the unit not to be habitable, or for you not be there after the permit is granted, there is the option for temporary relocation. They do generally have to do that if you are not going to be able to be living in the unit, and that's either going to be they have to place you somewhere similar in location, and that's something that's handled by the code enforcement division. But they either usually have to place you somewhere similar, with similar, amenities, similar location, similar, if you're close to schools, things like that. Or they would have to pay you a per diem per day for a hotel. If that hotel does not have kitchen amenities, food. If you have a pet as well, for a cat or a dog, they would have to pay you as well for laundry. So they do have responsibilities if they get approved for these permits, anything like that, and you are not able for a period of time able to be at the unit, then temporary relocation is the answer for that generally.
Does that have to be within a certain radius of your current living situation?
I don't know exactly how code enforcement determines that. They are the ones who would make that exact determination if, it is a comparable living space than what you have right now. And then if it's not, if you believe it's not, or what they're offering is not, then you can speak with code enforcement so they can advise the landlord that that is not a comparable space, and they would have to either do pay the per diem, or house you somewhere else that is comparable.
And are we guaranteed rehabilitation?
Code enforcement makes that determination, so they're the ones who take all the facts of the case and do make that final determination, and would and if any time you believe that this, that is warranted, contact code enforcement, because a lot of times we get tenants say, well, I was out of I had to stay in my sister's place or my brother's place for 2 months, and they didn't give me anything. Retroactively, it's very difficult for that to happen. So always contact code enforcement if you have any questions or doubts, or the landlord just says, you need to be away for this certain time, and I'm not going to pay you any relocation, or I'm not going to house you somewhere else. Mm-hmm. Next question.
Question to follow up, because I realize it sounds like there's a lot of construction of ADUs happening throughout the city, even with some of the folks here in the audience this evening. So I wanted to follow up on that because code enforcement isn't always sensitive to individual needs with respect to relocation or whatever is under their purview. So I wanted to, like, kind of following up on the construction related petition subject matter, is that something that could possibly be discussed in a hearing, say, like relocation, for example, as like perhaps a remedy for the construction-related decrease? Is that?
So the only remedy that would be available under the rent control law is to decrease the rent. We aren't able to we aren't able to tell the landlord you have to provide this relocation, even though code enforcement said no. We made a determination.
So, but some people might have like a medical condition, for example, and code enforcement doesn't take that into consideration.
Oh, just one moment. And I'm sorry, can you follow?
Yeah, sorry. So, like, for example, in the event that somebody has a medical condition, that maybe they even have a note from their doctor that's like, hey, it's probably not going to be good for you if you're going to be exposed to this dust and debris, for example, or that it might physically not be safe based on like equipment or materials that might be on the property for the construction project, right? Or even, for example, as we're approaching summer, to say to a tenant like, oh, just keep all your windows and doors closed, like that's kind of not really feasible, right? So are these the types of subjects that might be under the purview of a construction-related petition?
So they very well may be there may be that could very well could factor into the overall rent decrease amount that you do get in that. The things that you have stated, that the tenant is disabled, would have is having difficulty because of that construction, that can be factored into definitely
Like,
can be
obviously,
factored
you
into
wouldn't
that.
want to have your windows open if there's like kind of dust and debris, kind of
Right.
flying around.
Mhm.
But to keep them closed like during the summer is also not really feasible, right? Right.
Yeah, there's a lot of that. Yeah, so it could, all those things could
Enforcement
be.
there's no code for that, right? And there's no code for like, any medical condition, right? They talk about building code. But again, like, so it's kind of a fine line, calling code because they're like, well, we don't do that, is basically, right? It's
Okay.
like just not under their purview. So it's kind of a fine line that, tenants have a hard time navigating, I guess you could say. And so that's why I'm kind of, trying to see like, are those possibly the type of things that might fall under, the construction related petition?
Oh, yes, yeah,
subject
that could
matter?
definitely be factored in by the hearing officer, and the tenant or petitioner can make that argument with the hearing officer that, a condition that they have is causing them because of the condition that they have and the construction. So perhaps a larger amount of a decrease may be granted based on that. Not with us, unfortunately. We would only be able to do a decrease on that.
So I guess that's part of what my question is how do you recommend that a tenant navigate that kind of issue if like their doctor's note, for example, might say, hey, it's probably not going to be good for you to be exposed to all that stuff, during the course of construction, which is voluntary, right? It's not necessary construction, right?
So-
To build an ADU is not necessary.
So with something like a disability, if it's like a disability or anything like that, that would be, again, fall under the purview of the city attorney's office. It could factor into the overall decrease that you receive under the construction related decrease petition, but if you have a disability and the construction is affecting you based on that, you can contact the city attorney's office to see if there's a violation of the ADA, Americans with Disabilities Act.
Medical conditions,
Mm-hmm.
right? Not,
Okay.
not like a physical disability, for example.
Mm-hmm. Yeah, so we would only be able to do the decrease of the rent. That's all we would, the law allows us to do, unfortunately. Sure. Next question.
So we had two more. We had this one here.
Two more questions? And then we'll have time for more questions after at the end.
If a landlord decides to do construction, will the tenants be notified?
So they are supposed to file on with building and safety a means and method plan when they are doing any types of permits. So by the law of Santa Monica, they are supposed to provide that to you when there is construction going on. And that's something, if they are not for some reason, that's something that you would report to code enforcement or the building or the planning department, building and safety, if that has not gone on. But they are supposed to give a notification of that.
To the tenants?
To the tenants, yes. Mm-hmm. Okay, next question.
Can they raise our rent after the construction's over? Can they raise the rent of the property saying they made major amenities or brought it up to code, the building up to code?
Well, sometimes with that code, bringing it up to code, they may try to file for an increase petition. However, they have to make a strong argument with the hearing officer that the work that was necessary caused them undue expense and they are not making a fair return on the rent that they are currently collecting. So it's a pretty it's a high bar to reach in most instances. But just regular, we upgraded, the amenities to this, it's nicer now, there's a nicer courtyard, things like that. Generally, no, they are not able to raise the rent on that. It still has to stay at the general adjustments and the MOR of each unit.
So say plumbing, electrical, upgrading electrical boxes.
Right, just like that's necessary maintenance that they have to do, so that in most cases generally would not count as a reason for them to do an increased petition.
Okay, thank you.
One more question, and then we'll save the rest for the end. In the back?
Thank you for putting this on. I had a quick question. What if your landlord has your property listed as on the zero MAR and that Santa Monica database, but you're still paying rent? Any suggestions on how to handle that, or is that something to look into?
When it says zero, that a lot of the times could mean that it may have some sort of exemption. There's a couple of exemptions that may be in place for the unit. Sometimes they used to be like condominiums, that apartments that were converted into condominiums that we would not have control over the rent. So a lot of the times when it says zero, that's would be a case to contact us so we can look up in our database, does it have an exemption? What's going on at the property that we have never collected, that we have not received a tenancy registration for. So that definitely would be a case to contact us. It could be generally a lot of the times that they have some sort of exemption on the property.
Thank you.
You're welcome. All right, and we'll take the rest of the questions afterwards at the end of the presentation. Thank you.
So our next slide, this is one of the most important features of rent control is eviction protections, where an owner just cannot ask you to leave. They have to have a just cause under the rent control law. So with these eviction protections, under 1806, there is the tenant fault eviction where, for example, tenant doesn't pay rent. Non-payment of rent is a just cause for eviction. Violating the rental agreement somehow is a just cause for eviction. causing substantial damage, or being a nuisance is a just cause for eviction. Or refusing the owner the right to enter the unit after the owner has given you a 24-hour written notice. These all could be eviction actions that the owner could proceed in an eviction action in court. So the no-fault evictions include, where it's no fault of the tenant, it's just owner occupancy. The owner has the right to evict one tenant out of a unit in order to reside on the property. But there are requirements that the owner has to meet. And he has to have at least the 50% ownership as a natural person. He can't own it in an LLC or a corporation. So there's a number of requirements that the owner has to meet before he can evict for owner occupancy. Then there's the withdrawal of a property from the rental housing business, which is the Ellis Act, which any owner in Santa Monica can do. It's a simple procedure by which they have to submit to the Rent Control Board certain Ellis paperwork. And then we will monitor the Ellising of, or the withdrawal of a property. And that's what I currently do, is monitor the withdrawal of property, of rent-controlled property. Then we have the removal permit, and that's very hard to get, and it's only in certain circumstances that the board will approve a removal permit if the owner shows the board that the unit is economically infeasible to repair this unit. So then the board can permit a removal of the unit, but it's very hard to get. And then there's no fault evictions. And again, there's specific requirements that must be met. And then there has to be the payment of relocation fees, especially for evictions for owner occupancy. If the owner is able to do that, they have to pay the tenant the relocation fee that is set by the city, and it goes by the number of bedrooms. And also for the Ellis Act, the owner has to put in an escrow account and pay the tenant the relocation fees. And in some cases, the owner has to give the tenant an opportunity to correct, such as if they're a nuisance, he has to give the tenant an opportunity to correct whatever nuisance he's causing on the property. Or if he's violating a portion or provision of the rental agreement, the owner has to give a certain written notice to correct whatever the tenant is doing. And the end of the lease, it's not a just cause for eviction. And that's what we get calls that come in where the tenant's at the end of the lease and they think they have to leave, but the lease just reverts to month. So there's not a just cause under the rent control law for an eviction once the lease ends. So we get to the eviction for owner occupancy. Like I said, the owner has to own at least 50% as a natural person, and it can't be owned in an LLC or corporation. And it's limited to one unit. So there can't be other relatives living on the property that are listed in our regulations, like sister-in-law, mother-in-law. They can't be already living on the property, children. So there's only one eviction. And also comparability of units. So if the owner wants a 2-bedroom and there's 3 2-bedrooms, he has to evict the tenant that's been there the least amount of time. And so then again, also seniors are protected. The owner can't evict a senior out of a unit or a disabled tenant out of the unit unless the owner happens to be senior or disabled. And if the owner meets all these requirements, then he has to pay the permanent relocation fee to the tenant. And under state law, the owner has to give a 60-day notice for the tenant to vacate. And then under the law, the owner has to move in and he has to occupy it for 2 years as a good faith of evicting for owner occupancy. And then again, if you receive an eviction notice, please call us. We're here to help you and to see if the owner has done their due diligence and they're doing it properly. And then we come to the Ellis Act. The Ellis Act is a state law that allows the owner to go out of the residential rental business. It was enacted in 1986, and it was based upon, well, there was a lawsuit with an owner and rent control, and we didn't allow him to remove the property because he just wanted to go out of the residential rental business. He didn't want to rent anymore. And he went for removal, and it was denied. Well, then the state legislature got into the issue, and they passed this Ellis Act law because they said the owner has a right to go out of the residential rental business. And that's how the Ellis Act was born. So the owner has the right to go out of the residential rental business, period. And either tenancies terminate within 120 days or 1 year if a tenant is senior or disabled. And I usually will send out a form to tenants. Once I get the paperwork from the owner and I check it out and it's all done properly, then I will send out notices to tenant and I will give them the proper forms for them to fill out if they meet that requirement that they're senior or disabled, and they get the extension to 1 year. And withdrawal cannot be completed during a tenant's lease term. So if a tenant has a 1 year lease, then they can't the Ellis won't be complete while the tenant is in their lease term. And also condos. Condos cannot be withdrawn. Only under certain circumstances can a condo be withdrawn. It has to be owned by the same owner. And we've had that before where an owner owned all 10 of the units and he was able to withdraw that condo or torque a condo from rent control. So there's also the city ordinance, which provides additional protections for tenants, whereas if they have children that are in the school system, then they can't evict them until the end of the school term. And that's a city ordinance, and the city attorney can give more instruction or give you more details about that. And again, relocation benefits is an ordinance that has to be paid to the tenant. Usually, the owners will place the relocation in an escrow account, and once it's 120 days or the year, then it's going to be released to the tenant. It can be released earlier if the tenant needs any kind of fees to be paid for a down payment on like the security deposit or moving fees, things like that. And also, displaced tenants, they do get to the top of the list if they income qualify. So if you're being Ellis evicted, then you could potentially go to the top of the list of, say, Section 8 or the affordable housing if you meet their income qualifications. And you have the right to come back to your unit for 10 years if they come back into the rental business. So if they're going to re-rent that building, they have to notify the displaced tenants that they're coming back into the rental market, and it's a 10-year period. Now, the renting is the most important thing because if they come back within 5 years, it's the rent control rent, as if it was never Ellis with all the annual increases. If they come back after 5 to 10 years, they can offer to the displaced tenant at market rate. And then we come up to buyout agreements, and this is a city ordinance, and they wanted some kind of regulations to even the playing field for tenants because they were seeing that owners were just, giving these. They wanted to buy out tenants, and they wanted tenants to be protected so that they have rights and know what their rights are. So, you have the right not to enter into a buyout agreement. It's voluntary. You don't have to consider it. And if they keep on trying to get you into a buyout that could be construed as harassment, you need to contact the city attorney's office. You have the right to consult with an attorney and or the rent control board before signing the agreement. And the most important thing, you have the right to cancel if you change your mind, but it has to be within the 30 days after signing. And also, there's a minimum amount that the owner can offer a tenant, and it goes by it's based upon the relocation. So, but you can negotiate a higher amount if you and the owner come to an agreement.
How does those charts work?
I can explain.
The first one, the one on the left is region, what is the number of units mean and the average?
Right, so this is for 2024 numbers, based on the buyouts that were, because they do have to file them with the city clerk, and that information gets to us whenever there is a buyout at a rent-controlled property. So as you can see, there's the different regions right there on the chart on the left, and what the average, so that how many units there were buyouts in each region, and then the average right there, as you can see, C has 0 since there were no buyouts in that region. And then the one on the right here shows based on the number of bedrooms in the whole city, what the average was and how many were filed for each type, right there.
Yeah. Got a question?
Oh yeah, let me go. Yeah. Oh, thanks.
Is that page, can you look that page up on the line?
Yes.
Okay.
Yes, you can.
Sorry. We were led to believe by our previous owner that our property, which consists of 10 units, 9 units, could not be divided. That, because we had talked with the owner over the years about that they wanted us to purchase the property and blah, blah, blah. But when, in this last few years, we've been talking more and saying, well, you know, this individual or couple would like to buy this part of the property and this individual, and they were like, no, you can't do that. You have to buy the whole thing or nothing.
Right.
The new owner bought half the property and someone else bought half the property. So we now have 2 owners, which changes our status as far as buyout goes. Because we now have 4 units on one side and 5 units on the other side.
But it's one parcel.
No, 2 parcels.
It's now subdivided?
Yes, the new owners, we were given separate paperwork. You know, people on one side of the driveway were told their owner is this, and the rest of us were told their owner is that. So it now changes the configuration. Yeah.
It doesn't change the configurations, but I mean, if it's subdivided, then we have to look at it, because I don't know, and this is a rent control building?
Yes.
There are 2 separate lots. Same owner had bought both lots.
Mm-hmm.
And one in 1947, one in 1969, they owned the lot. And they were convinced that they would get a better price if they could sell as one sale, knowing that it would be 2 escrows. And that's what happened.
Okay, but is it separate parcel numbers?
Yes.
It is,
Separate properties on
that they subdivide, okay. That's something we have to look up, it's, you know, to see in the rent control database, did we go ahead and give it divided, because there's 2 separate parcel numbers, which means 2 separate properties? So we need to look it up, just to make sure of what's going on. Because at first I thought you were talking about a tick, but it sounds like they actually did subdivide it.
It was always subdivided from the beginning.
Okay.
2 different owners like prior to 1969.
Okay, just call us and we'll look it up and just know for certain what we have.
Hello, my question doesn't fit easily within your presentation, but there are 6 apartments on my property. There's a lot of yard included, which is just background. I'm trying to figure out how to present this to you in the minimal amount of words, but my apartment is owned, the building is owned by a family lease, or at least it was, at least 2 or 3 times now they keep saying, oh, well, I'm a new owner, but one time I checked online, there was no escrow, there was no record of a property going through a physical sale, so I think they're just transferring it between parties in the same family trust. That's my best take on it. The owners go to great lengths to not let me know who they are. They don't put things in writing. They enter my apartment all the time without, giving me any advance notification. I hear them talking mostly in the apartment upstairs from mine, out in the yard. Sometimes it's the workers. I think the tenant upstairs, if she is not an owner, she's related or affiliated with the family trust. And I hear people, but I don't see them. And they're saying things like, well, we want her to leave. And they're acting like as if I am a house guest, that they have taken my apartment off the rental unit. They put in a new panel a couple of years ago, or about a year and a half ago, on the back garage. At first it said apartment F, which is my apartment. They changed it to house panel. Again, it's a shared meter with the upstairs apartment. I don't know what the front building is. They're for a quadruplex, fourplex. They're trying to harass me to death so that I will just walk away, leave not only my apartment, but my housing voucher and my personal possessions. I mean, I've heard them say as much. What are my options? What can I do? I've been there over 5 years now, and I don't really want to move, but I've endured the remodeling of the front fourplex for 2.5, 3 years, sawdust, circular saws buzzing in the backyard where my apartment is at the back of the property. What can I do? I don't want to leave.
Right. Well, the city has an anti-harassment law, anti-tenant harassment law. So you have to contact the city attorney's office if you really believe that this is harassment. And then you will call them up, make a complaint, and they'll investigate the harassment. But you just need to call the city attorney's office. And as far as how title is held, the owner has to register how title is exactly held. And if it's in a trust, that's what they need to register with rent control and name who the trustee is. And usually, sometimes we get information from the county assessor on how property has changed hands and how the title is held. So you can call us, and so we can look to see what we have in our database to show title.
I can call rent control board?
Yes, call rent
Okay,
control.
I'd like to start
so
there.
we can look it up.
Because it's difficult. I could respond to a written eviction notice, but just, it's hearsay. So how do they're going to deny everything. I've heard them say as much.
Right.
But they're really nasty.
Right,
really
but
mean.
it sounds like harassment, but we don't make that determination. It's something the city attorney has to look into for you.
Okay, thank you.
I have a question about owner occupancy eviction.
Sure.
We have a new owner who just purchased the building, and there are 6 units. Some are occupied by seniors. Some are occupied by tenants who have been there many years. On your slide, it just made reference to various restrictions on selection of a unit that an owner can choose to evict a tenant. What are those restrictions?
Well, part of the restrictions is the comparability of units. So in a 6-unit building, if you have, say, 3 one-bedroom units.
Actually, they're all the same.
They're all the same?
2 are on the bottom.
You have to evict the
4
tenant
on
that's
top.
been there the least amount of time. That's the first thing. And then there's other restrictions where if they're seniors or disabled, they have extra protections where the owner can't evict them unless the owner happens to be senior or disabled.
So that senior owner is not restricted to evict?
No. If he's senior, then he's allowed to evict the senior, and senior starts at 62.
But otherwise, it would be the tenant who has the least seniority in the building?
Yes, yes.
And is there a statute you can refer us to?
Yes, that's under our 1806 of our regulations. And also in Chapter 9 goes into the details of the requirements for owners, having a 50% ownership, not in an LLC, comparability of units, their good faith requirements. So Chapter 9 goes into more details.
Thank you.
I have a couple of random questions just based on the whole presentation. Would a new roof be considered, we just had a new roof put on our building. Is that part of, would that not be something they could raise the rent over?
So far as the increased petition, they're really going to have to show that they're not making a fair return because of that. And that was something that was definitely required for the property. So they would have to prove that. And even if just because it was required doesn't mean that the increased petition would pass. They would still have to prove that with that, they are not making a fair return because of that safety requirement that had to be put in place. So they really have to, and that would be for the entire building. They would have to provide financials, proof, evidence of what was spent, how much different things cost, why the old roof couldn't stay in place, and why it had to absolutely be changed as a safety matter. So they would have to make that. They would have to prove all that on all the tenancies, not just one tenancy or not just their selected tenancies, on all the tenancies in the building, they are not making a fair return because of this requirement.
And what is considered a fair return?
That, that there's no specific measure for that. They would have to prove that to the hearing officer that they're not making that. So there's no specific number or anything like that. That's something that they would have to prove to the hearing officer that, and then the hearing officer would make the determination. So there's not a set number or a set percentage of that signifies not a fair return or anything like that.
There is a formula that.
Yeah, what's the formula?
That they compare the 1978 net operating income versus what they're making today to see if they're getting a fair return. And if an owner has a market rate tenant, that's going to boost their net operating income where it looks like they're having a fair return. That's why we've had hardly any rent increase petitions for maybe 7 or 8 years, because it's very high hurdle to get to that point when you have to compare 1978 to your current net operating income.
Right. Okay, that makes sense. Thank you. And one more question, kind of small things, but just curious how this works. I've been in my unit for like 28 years. There's a cracked window, pretty severely cracked window that was there when I moved in, but I just didn't care and I didn't bring it up. There's a new owner as of the past maybe 4 years. Also, like my bathroom window doesn't completely close properly. Am I allowed to ask for the severely cracked window to be replaced and my bathroom window to be correctly closing so I could lock it? And can they say, but you haven't mentioned this in 27 years. Why are you mentioning it now?
No, that wouldn't factor to. It would be what is really going on right now and the maintenance of the unit. Just because you hadn't mentioned it in the past does not disqualify you from filing for a rent decrease petition or anything like that with us, because that has to do with the overall maintenance of the unit. And just because it hasn't been maintained in a while and you haven't made a complaint to the ownership does not preclude you from filing a rent decrease petition with us. So that's certainly something you can ask for.
Well, is the first step to ask the landlord to fix those two things?
That would be the first step in writing,
Okay.
email or a form that we have on our website or a letter that you send them.
Okay.
So in writing, and then within 30 days, if that's not remedied, then you could file the rent decrease petition with us.
I see. So again, if they say, why haven't you mentioned this before, I don't need to answer?
There's nothing specifically in the rent control law that says you have to answer anything like that. But that wouldn't not preclude you from going through our rent decrease process.
Okay, and is it the same thing for a fireplace? I understood that there needs to be some mortar filled in before I can start using it again. Is that something the landlord seems to think, oh, it's never been used, but I did used to use it, and now it's probably more deteriorated over the years. Can I ask for that to be in working order?
So
It's a wood-burning fireplace.
Oh, okay. So you used to have the amenity.
Yes.
The amenity before.
Yes. Mm-hmm.
The fireplace.
Yeah, that's code is going to determine,
Mhm.
about the fireplace and whether it's safe.
Who would determine that? Code enforcement.
And even if you file a decrease of petition on that, the hearing officer is going to look into the feasibility of that fireplace being operational. So it's a little iffy that they have to look at both sides if it's going to be safe for you.
Well, can't they just fix it and fill in the mortar with a licensed fireplace company?
That could be. If they have to get permits, and that's the question, will they have to get permits for this?
No, they don't.
So.
Okay, and then is there a number for this code oh, okay. Code enforcement, I was gonna say, can that be provided?
Sure. I mean, if you're within Santa Monica, you could just dial 311 and ask to speak to code enforcement. Yeah.
Okay, thank you.
I can talk, I can speak loud. I have a question about the actual physical rent check being deposited. We put in the check 2, 3, 4 days before the end of the month. It gets dropped manually, gets dropped in a manned mailbox. Over the last year, repeatedly, every month, it's become every month. It does not get deposited until 6th, 7th, 8th of the month. So it shows consistently that the check was cashed, was deposited only 7, 8 days into the new month, whereas it was, dropped. And it got to a point that I'm actually taking photograph of it, taking photograph of everything, like documenting it just in case. But how could I avoid that? I mean, I call them and I say, why was this so delayed? And they say, blah, 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 no.
Yeah, the rent control law doesn't address that issue of how long they deposit a check. I mean, that could be addressed as, sometimes it may be harassment that they're not depositing. Sometimes we hear from tenants that the owner hasn't deposited 4 months of checks until they just do it all at once, and the tenant doesn't have enough money in their account. And sometimes that could be construed as harassment. But otherwise, the rent control law doesn't address that issue of when the owner deposits the rent check.
Could that be basis for possible eviction? Because they say, hey, you're always, look, in the 1 year, you're repeatedly late, whereas one is not.
It's not a just cause for eviction if you're late, unless you don't pay at all. I mean, that's one of the just causes is non-payment of rent, but you're paying your rent.
No, it's, I mean, the date is 28th of the even previous month, for the next month. So can they deny it though?
No, they can't deny a rent check from you. Again, that would be construed as harassment to deny a rent check from you.
So if one gets a 3-day notice eviction, that's harassment.
That could be construed as harassment. The city attorney is looking into those types of instances where there's been long-term tenants that see that type of thing happening.
Yes. I mean, over 1 year now.
Yeah.
Every month.
Yeah.
They never charged you for a late payment?
No. No.
Okay. Yeah.
Can we have?
you had mentioned earlier that if you have to move out because of construction, they have to find a comparable place for you to live. Well, there's no comparable place in Santa Monica. What are the parameters for a comparable place to live?
That would be more with code enforcement. They're the ones who, the city codes are the ones that dictate that. It's not dictated in the rent control law. But if there is that, code enforcement would be the best department to reach out to, and they would have what exactly they would use as their parameters to be called comparable.
Yeah, but for instance, we've lived there for 30 years,
Mhm.
and so the rent is lower than any place you can find.
Oh, so generally you would still keep your rent. So you would still pay the same rent. They can't raise, when they temporarily relocate you, they can't say, well, this is, a slightly nicer place, so we're going to charge you double. You would still pay the rent within the MAR that you are being charged. Mhm.
I think I asked a question around this earlier, but, if you have doctors in a hospital that you need critical access to, does that figure into the relocation at all? Or are they allowed to say, well, there's a hospital in your new community?
That could be, yes. That could be something that code enforcement, may be a factor as to finding comparable housing. And code enforcement would look into that. You would say, well, I need to be close to this, and I'm close to that. Like, same with like schools or something like that. I need to be close to my child's school. That would be some of the parameters that they may use.
Okay. And the papers we received that showed a change of ownership show the owners as being an LLC, but they've already informed us that they intend to move tenants out in order to install elderly family members in the apartments. So if I understand you correctly, they're not able to do that.
Mhm. No, they are not. Yeah, not if it's under an LLC. If it's under an LLC, they would not be able to do it at all. Okay, and we have a couple questions more. Like 3-4 more questions. They are not allowed to do that they have to act in good faith for any owner-occupied eviction. So they can't, the reason of them changing ownership just to do an owner-occupied eviction to an individual, that could be seen as doing the eviction not in good faith. That could be a defense for the eviction.
It could also be argumented that, they're a single member LLC, they bought it because of liability, and then they wanted to move into it because, they want to move into it. I don't think you're gonna have a good chance of them not being able to evict somebody.
That would be decided by a judge ultimately. Yeah, a judge would they would have to present that argument. Mhm. And then next question.
Does the owner have to replace an old carpet that's very old, let's say more than 10 years old, and also it's damaged due to water leakage through the window?
Well, they have to maintain it. Of course, a lot of the times what good condition is varies from what the tenant believes to what the landlord believes. Other cities, like you may know, have time requirements, a year requirements that things have to be changed. Santa Monica does not. However, if you believe that a specific time range, we don't have that. However, if you believe that is no longer under good condition, a lot of things have happened to it. There was
a damage.
It's damaged because of water or anything like that. That could be something that you could seek a rent decrease for through our process.
But can I ask them to replace the whole carpet? I mean,
You can ask, and if they say no to your satisfaction, or if they do it and it's not to your satisfaction, then you can file for a rent decrease petition, and then that would be ultimately decided by the hearing officer.
So whatever they decide, the way they want to repair it, do I have a say-so in terms of they want to put some kind of a walk-in mat or something?
It has to be comparable. It has to be comparable to what you have. Yeah. So it has to be comparable. So that definition, of course, the hearing officer would be the one making that determination. Is this comparable? You can always ask. There's no harm in asking. But if they deny that and you think that they put in something that's totally different, that you see as a downgrade, worse quality, that could be something that you may seek a rent decrease for.
Okay, another question. We used to have on roof over the air antenna.
Mhm.
That's a big building, 32 units.
Mhm.
And each apartment had a antenna outlet, by the wall. Anyway, and already a few years ago, it stopped working. I asked them to fix the antenna. Sometimes, once in a while, the antenna wouldn't, work correctly. There's an amplifier, so on. They didn't want to fix it. They said, get a cable. Amenity, right?
So did you live there, did you move in before January 1st?
1998.
Oh, so again, that would go to, was the amenity there when, in 1978, when rent control started? That's what it would be based off of, if that, if that was
You
there.
can see TV outlets in the wall. Antenna is on the roof, a big antenna. And each unit has,
Mhm.
outlets.
Right.
So in other words, you can see a proof.
Mhm. Yeah, so it would be based on, yes, that 1978. It would still go back to that being
How
a
do you go back?
pre-1989
You
tenant.
see
Yeah.
the original registration.
You can see that. I don't know if they would particularly put that exact thing in there. So it would be the responsibility of the tenant to basically find any type of proof that they are able to, that was in place in 1978. So the burden
how
would
do
be
I
on the
find
tenant.
proof?
That would be up to the tenant. Yeah, you can perhaps take public records requests throughout the city, different evidence finding measures. People maybe that have lived there. It would be the responsibility of the tenant.
To prove.
Correct, that amenity was that amenity was there. Yes. Yeah. Okay, and then we have time for two more questions.
Last question, back to the ADUs that were constructed last year and a half. We recently found out that they had put aside, we had a couple barbecues. One of them was owned by us and another tenant had another. And so they put it aside temporarily since they built ADUs super close to the original property. And they essentially dispensed recently of the barbecues, even though they were for a year sitting kind of on the sidelines. What can we do with that? Do we do some kind of petition with no notice? We were not notified that they would just throw them away. This was a perfectly good Weber barbecue with utensils and all that stuff. And so, we don't know if we should reach out to them and say, look, do we take you to small claims for this thing? Or do we do some kind of petition for a rent decrease for, throwing a private property?
Right, so that they took the amenity away?
They actually threw it away, the trash. It was
okay.
private.
That's something you would go to small claims court. Any personal property that may be destroyed by the owner or confiscated, anything like that, that would be something you would seek in small claims court.
Okay, yeah, no, and the same thing with furniture,
Right, yeah, if something's damaged because of non-maintenance, yes, that'd be.
He threw it away with no notice.
No notices.
Yeah, that could be something in small claims court. And we have time for one last question. Unfortunately, you have to use the room.
I have a question. If the owner decides to go through the Ellis Act and evict the tenants, how about if we refuse to move? What's the repercussion of that?
Well, we just had some tenants do that. The repercussion is the owner can attempt, they're going to evict you. You're going to go through the court system, and it's going to be up to a judge to determine if they did the Ellis correctly and whether or not a tenant needs to vacate their unit. But it's pretty much with the Ellis Act, the owner has the right to go out of the residential rental business. And as I said, well, there was the Barrington case in LA where tenants did get together because it was a bad faith eviction, because the owners weren't going out of the residential rental business. They just wanted the tenants to leave so they could renovate the sprinklers because they were having fires. But they were going to go back into the residential rental business once the sprinkling system was updated. So the tenants did sue and they were successful last year. So it really has to rise to that level where the owner in bad faith is not Ellising the building.
So what is the repercussion of refusing to move?
Eviction. The owner will go through the eviction action.
So we do have, unfortunately, have to end. We do have cards. You can contact us tomorrow if one of your questions is not answered or to expand furthermore on it. So you can call us. We are open tomorrow from 8 a.m. to 4:30. We do close from 12:30 to 1:30 for lunch. Okay, so thank you so much for attending.
Thank you guys for coming out.